for joining us this lunchtime. We're excited to be running this masterclass on dispute resolution for you today. This is another masterclass from Law Careers Net's autumn season. We've got a great panel today and a lot to get through, so we hope that you'll enjoy this masterclass and come away with some good knowledge and get involved with the conversation as well. We always start our masterclasses with our learning outcomes. So by the end of this masterclass, you should know how to break into this practice area, know what the work of a dispute resolution solicitor involves, and knows about some of the key issues affecting this practice area and the profession right now. So before we get going, we'll just go through our house rules as usual. So first and foremost, please do use that Q&A tool to ask your questions. The sooner you ask them, the more likely they are to be posed to our panellists, but I'll be keeping an eye on those and sort of dotting those throughout and also saving some for the Q&A at the end as well. Please note this masterclass is being recorded. The recording of this session will be sent to all registrants after today's event, and it's going to be available on our YouTube channel too. As I mentioned, this is one of our autumn term masterclasses, and we've been running a whole range of masterclasses so far on both practice areas and sort of skills-based themes, from M&A to IP and private equity to commercial awareness and law firm applications. And you can check out all those previous masterclasses on our YouTube channel. Next Wednesday at 3 p.m, we're actually hosting a masterclass called The Differences Between Law Firms and What It Means, from national to international. And we're going to be helping you in that masterclass sort of work out what the different firms are and what that means. So a link to that event will be in our follow-up email. Finally, talking about events, we've recently opened submissions for the 2025 Student Law Society Awards already. You might have seen the image in the waiting room. So please do take the member survey to let us know how your society supports you, and they could be up for an award at the award ceremony next March. Right, let's start with our poll just to see who we've got here with us today. So if you could all take a minute to please answer and let us know what stage you're at. Thank you to everyone who's answered. Just going to give it a few more seconds. It's always good for our panellists to see who's with us as well, so I will share that in about 10 more seconds. Okay, let me share those results. Nice mixture today, lots of undergraduate students, some first years, second, third years and non-laws, quite a few postgrad and a few in work as well. And if I could just find out how much you already know about dispute resolution, please. Do you know absolutely nothing, a little, a lot, or are you an expert? I'm presuming not that many people are going to choose that one, but it's just nice to hear from you, and also for our panelists to see how much people know as well. So if you could just take a second to answer that, and we'll share that in a moment. 5 or so more seconds on that one. Surprisingly, nobody has said they're an expert, which I guess is a bit of a relief. I end the poll. Share results. So some of you know absolutely nothing. That is absolutely fine. A lot of you know a little, and some of you know a lot. So hopefully by the end of today, you'll know a little bit more than you did than at the beginning, which was the aim. Great. So I think it's about time for our panel to introduce themselves. I'm just going to go around and ask them to say hello and say a bit about themselves and their firm. And I'm just going to go by the order that I have on my screen. So Stephanie, first of all, it's over to you.
Hi everyone, afternoon. I am Stephanie. I'm a partner in the dispute resolution team at Travers Smith. I'm also the firm's co-head of graduate recruitment. Travers Smith is an independent law firm based out of London. We're full service, so we do everything under the corporate commercial umbrella. We're about 90 partners and 400 lawyers or so. In terms of my journey, I have been at Travers Smith my whole career. I began my training contract at Trowers in 2008, qualified into the disputes team in 2010 and became a partner in 2018.
Thank you. Jamie, you were next for me.
Hi everyone, thanks for joining us today. So my name's Jamie de Souza. I am a partner in the commercial dispute resolution team at Trowers and Hamlins. I'm based in the Birmingham office. I trained at a regional firm and spent 11 years there before joining Trowers about 6.5 years ago. And got made partner, I think now, a few years ago. So yeah, broad commercial litigation experience, corporate commercial litigation, and one thing we do quite a lot of, particularly in the team in Birmingham, is fraud-related matters and fraud investigations.
Thank you. And finally, Preena.
Hi everyone. My name's Preena. I'm a senior associate in the commercial dispute resolution team at Mills and Reeve. Mills and Reeve is a national full-service law firm, again, corporate commercial work. In terms of my background, I actually I qualified at a smaller regional firm. I've been qualified for 8 years now, and moved to Mills and Reeve about 5 years ago.
So let's get started. And we always sort of start by defining what the practice area actually means. So Steph, to you, a very basic question. What does dispute resolution actually mean? And then we always like to ask the sort of question that we do actually get asked is, aren't all legal cases disputes?
Yeah, so that's a really good question. I completely understand why it would be asked. So what is dispute resolution? It really is what it says on the tin. So we are engaged when a client is embroiled in a contentious issue, a dispute, and our job is to assist with the resolution of that issue, that dispute, whether that's through litigation or arbitration, and quite often mediation along the way in either of those routes. All cases that you read in the study of law are absolutely disputes. That's why they have come before the courts, and that is how the common law comes into being. So it's really, really important. And that is very much my world, our world, all of those on the panel. There are plenty of other types of law that are practiced in my firm and the firms of the other panelists, which don't go anywhere near the legal cases that you read about. So my M&A team here do they buy and sell companies, for example, and the financial services team advise clients, asset managers on their regulatory compliance. So they will often utilize the law that is created in the course of legal cases, but they are not themselves in what they do generating those legal cases. I hope that makes sense as a distinction.
It's a good summary. We actually have already done this masterclass with financial services area and M&A, so please go back and watch that to see the kind of differences in practice, which is great. And Preena, could you sort of summarize the sort of different types of disputes that you might come across as a lawyer in this area?
Yeah, absolutely. So commercial litigation can encompass a broad range of disputes. So you can have some firms where lawyers are kind of delving into lots of different areas. You can have some firms where people are more specialist. Kind of the Mills and Reeve angle is we do have more specialists. But in terms of different types of disputes, so like I said, you've got kind of general commercial disputes. You might have a dispute with, say, an intellectual property angle. So a trademark dispute or a patent dispute. You could have a dispute relating to insolvency. So where companies have gone insolvent or individuals have gone insolvent, you could have a dispute arising out of that. Different other areas are things like defamation and reputation management. And you could have corporate kind of shareholder partnership disputes. But then there are also other disputes that are kind of outside, slightly outside the realms of commercial dispute resolution. So you could have employment disputes, employee and employer disputes, real estate disputes. You've also got things like insurance related disputes where you're acting for the big insurers. So there is a very wide range of dispute resolution. I suppose in other areas, things like personal injury, clinical negligence. So dispute resolution, there is a whole host of different areas that are dealt with as part of this.
That's great. And just sort of continuing on from that, I guess a good thing to summarize as well, the different type of dispute resolution options that there might be. I think we might have mentioned arbitration or mediation. I can't remember which one, but yeah, if we could go through that for our audience, that would be great.
Yeah, so in terms of kind of the main dispute resolution options, I would say that the most known about one is litigation, which is kind of court proceedings. taking a case all the way through to a final trial before a judge in one of the courts. But there are other options in terms of dispute resolution. So another option for dispute resolution, which is something that Stephanie touched upon, was arbitration. So arbitration is a form of dispute resolution. It is not done through the court system. It's where you have an arbitrator appointed by the parties, and that is usually a subject matter expert in a certain area, and that process kind of goes through the same stages that you'd go through in a litigation process, but it tends to be a little bit more of a flexible process. It's also a confidential process, so there are advantages to it. And also, not trying to get too technical, but that there are also some advantages in terms of when you get a final decision, a judgment, for example. There can be issues in terms of enforcement if you've got opponents that are based in other jurisdictions, and arbitration could be a good way of resolving those disputes, because arbitral awards, there are specific rules, which means they're recognized by other countries, for example, and it doesn't involve some of the steps you have to go through when you go to court. So those are two options. Another option is mediation, which is essentially a form of alternative dispute resolution, which is it's a without prejudice process, which means it's a process that the arbitrator doesn't know about, and it's a flexible process where parties come together with the assistance of a third-party mediator to try and resolve their disputes. So a mediator is essentially facilitating discussions between the parties and trying to get them to a position where they reach a resolution. So again, mediation it's a very flexible process. It's confidential, and it allows parties to come up with kind of very creative solutions to their problems that a court or an arbitrator may not necessarily be able to award.
Thank you for that summary. That was really clear. Jamie, I wasn't sure if you had anything to add, or, this might be a strange question, but do you have a favourite type of a favourite option amongst those?
The one that works best for any given case. I think the starting point is that they're not necessarily mutually, they're not necessarily exclusive in terms of the way they operate. So, for example, litigation, once you've embarked on court proceedings, you're in the process. But there's nothing stopping you, and actually it's very much encouraged that you have mediations during the lifespan of the court proceedings. So mediation is quite commonly used when you're a little bit further along the process. So, for example, we deal with mediations without court proceedings ever being issued, but we equally deal with court proceedings once the parties have a much clearer picture of the opponent's case. So whether that be at close of pleading, so once people have done the particular claim and defence, whether it is once they've seen the documents, again, once disclosure's taken place. Sometimes once they've done witness statements, it is not unheard of to have mediations right before trial, or equally after trial before judgment, or even after judgment before any application for permission to appeal might be made. So I think the lifespan can be very different in any given case, but I think the starting point, I think, and something Stephanie touched on, is dispute resolution, and it is all legal cases, disputes, etc. We are engaged when I like to say there has been a problem, we're a distressed purchase, either something bad has happened and you want it resolved, or you're on the firing line of something bad that you might have done. So if you kind of think about it in that basic context, a big part of dispute resolution options is then looking at, and we'll touch on this when we get into how we kind of look at our cases, but is looking at the best thing that fits any given case. And dispute resolution in many respects can simply be guiding a client to the right way of resolving something before it becomes a fully blown dispute. So it is very much more risk management type approach. And I think all the panelists here today probably undertake a massive mix of that very, very early advisory of, I think we've had a problem on a contract, we might have done X, Y, and Z wrong. How can we best steer this so we don't end up in a dispute? And that is very much a dispute resolution option. Or they could just go, do you know what, let's just roll with it and hope that nothing happens. And if it does, we'll let you know once we're on the back end of a live claim. So that's probably the only thing I would say. The only other, the one additional point is obviously the court's approach in litigation is very much focused on getting as many cases resolved as possible. Very few cases percentage-wise end up at trial. And the court will now enforce in certain courts things like financial dispute resolution hearings, where you actually have a judge doing a kind of very short form type of mediation in terms of its kind of scope, but trying to get the parties to kind of come to a sensible resolution. So there's a real mix, and there's no one size fits all. Obviously, construction litigation, you have adjudications as well. Yeah, there's a mix, and you look at applying the right one at the right stage.
Thank you. And Jamie, just sticking with you, this is a specialist area, in the landscape of sort of legal practice areas. It's likely that you're just going to be doing this as a dispute resolution lawyer. Is that correct?
Yes and no. I kind of like to think that one of the big reasons why I picked going into dispute resolution was because of the variety, actually. I wasn't suited to doing transactions after transactions. So, for example, I think, like all of us touched on again, it could be on one day it could be dealing with a commercial contract type dispute. On the next day, it could be dealing with a shareholder dispute. On another day, it might be a fraud investigation. So yes, it is very specialist in terms of knowing the processes for each, but really, we're generally very much sector agnostic. We are broad in scope in terms of the type of cases that we might litigate, because a lot of them there will be underlying similarities and strategies that we deploy, and we just have to get our head into whatever the law, whatever the technical aspects might be. So if you're dealing with a product related dispute, and you have to really get into that product and looking at experts in that product, it is specialist, but it's also quite broad. It's probably not very clear. Hopefully Stephanie and Preena agree that the scope of a litigator's life is varied, but yeah, we are a breed of our own as well.
No, that makes sense. Thank you. And maybe we can, just before we move on to sort of talking more specifically about the work that you do, Stephanie, I wonder if you wanted to just summarize the sort of clients that you might work for in different sectors. I know Preena did a great job of summarizing the different types of disputes and where they might come from, but yeah, if you could give your view on that, that'd be great.
Yeah, and that probably picks up quite nicely on what Jamie just said, because I completely agree with him about the breadth of the work that we do. We are specialists in dispute resolution. So we are specialists in strategizing to resolve problems for clients, but the range of those problems is very broad indeed. And you can be doing a fraud dispute one moment, a noise nuisance case the next. I do some investigations work as well, regulatory investigations, tax disputes, pensions disputes. It really can be anything. And that's part of what I love about it, to Jamie's point, the breadth of it. And what that means is that my client base is really broad too, which is very, very enjoyable. I'm not just seeing the same people again and again. In terms of who we act for at Travers Smith, it will generally be acting for a corporate rather than an individual, although very occasionally we might act for an individual, but it's generally a corporate in corporate and commercial disputes. But the individuals within those corporates from whom I'm taking instructions will be very different from one another. And I might, on a smaller dispute, be dealing with the CEO of a small company who doesn't know much about litigation, has never been involved in the process before. On larger matters, I might be acting for a bank, and I'll be dealing with the general counsel, the top lawyer in the bank, or a litigation specialist in the bank. So my clients all have sort of different levels of sophistication when it comes to the law, but also a very, very different outlook on life, which keeps things interesting. I also act claimant and defendant side. And so client profiles will look a little bit different, again, depending on which side of the dispute that you're sitting on.
I'm really seeing what Jamie said about it being specific but varied, because it sounds like you do a lot. And Steph, just sticking with you, because I want to kind of dive into the mindset of you and when you're working. So firstly, you get a new case on your desk. How would you go about understanding what it is that your client wants to achieve and the sort of range of solutions that could be open to them?
This is absolutely what I love about our practice area about dispute resolution. I'm sure Jamie and Preena feel the same. It's really a problem-solving exercise. To Jamie's point, we are instructed because there is a problem, and we need to figure out the scope of that problem. As you say, then what are the possible solutions? So I really start from the perspective of, right, there are different pieces of the jigsaw here, and I need to put them together to come up with the bigger picture and understand what's going on. And that process will look different depending on the nature of the matter at hand. But generally, we will dive into the documents first off. We will review those, we will analyze them, we will put those pieces together. We will speak to key individuals involved in the matter, and the relevant stakeholders at the client, so those instructing us. And gradually you start to build up a picture of what has gone wrong, and what the client's options are, and you can start to think creatively about the solutions. And generally there will be more than one solution. There'll be plenty of options available to you. It's like a game of chess. You pick your next move, and often the direction of travel will depend on client related factors. For example, what is their risk appetite? Do they want to make this go away quickly, or are they content to be embroiled in a dispute for 3 years and take it into a public forum? This court is an open public forum, and everyone will hear their dirty laundry aired in public. Some clients will be fine about that, others won't. So it's those sorts of things that go into the mix to help us determine what the best solution is for them in the moment.
And you have to be quite flexible, Steph. So, as things change and new information might come to light, you might have to pivot your strategy quite quickly, right?
That's exactly it. You're dealing with new information all the time from your client, and it's amazing how often honest clients sort of change their minds about things, or give you a slightly different fact pattern. And it's just human nature. We forget things or don't provide all the relevant information up front. So you need to move quickly in response to that, and in response to different commercial pressures that they might be facing, right? And some of what I do hits the press quite quickly, and that changes the dynamics. You've got to be ready to respond to that. But most significantly, you have an opponent. And that's what sets this practice area apart from others. You have an adversary, and they are making moves all the time as well. And so you need to strategize according to what they have done to position the client as best you can.
Jamie, you were nodding quite vigorously there. Wasn't sure if you wanted to add anything.
No, just it is. You are always looking at the next move, and just one of the things Stephanie said about you dealing with your opponent. Here you are both talking about your client's opponent, as in the other party to the dispute. You are also then dealing with your, I say opponent, your opposing solicitors or counsel team, and the moves that they might make. And I don't know whether we might get onto this later on or not, but I'm gonna just touch on it now. So one of the things that we will quite often find is, you're not going to necessarily agree with your opponent's solicitor on the facts of the case, but what you ought to be able to agree is a way to kind of bring the dispute to the right forum at the right time in the right way to bring about a resolution. And actually building that rapport is not always easy and is not always possible, but it is important to have that professional relationship with your opponents so that you can both move the case in the direction that it needs to go. Like I said, it's not always easy and it's not always possible, but that is in theory the kind of way in which you go about it.
Great, thank you. Preena, just listening to all of this, I'm thinking that a huge part of the role also might be sort of people and expectation management as well in terms of your clients. So, I mean, I guess how much of your job is actually sort of enacting that solution, and how much is sort of speaking to them and trying to convince them of the right thing to do, or what you think is the right thing to do at that stage?
Yeah, I think I echo everything that Stephanie and Jamie have said about the process, and I think very much we are dispute resolution lawyers, and resolution is at the forefront of our minds. So really, trying to find a solution to a problem is what we're doing. It's not necessarily kind of a linear approach. There's lots of different factors, lots of things that can change during the lifetime of a case, and that changes your strategy. But ultimately, the objective is to come up with a solution. But we are dealing with people at the end of the day, whether we're dealing with, you know, corporate businesses or not, we are dealing with the people that are working in there. And often these people are, you know, people who've been involved in the background to the dispute, may have been involved in the, I don't know, the negotiation of the contract or the kind of implementation of the contract, and the relationship has broken down between both sides. So often you can be dealing with people that are in stressful situations, that feel, you know, how emotions are running high, principles, everyone has principles, everyone has very, very strong views about who's right and who's wrong. But I think that's kind of our role. It's to be that neutral party in a situation, to kind of dissect the information and give our clients what the options are, what the kind of the risks of each option are, what the benefits are, because there is never just one solution to a problem. And kind of discussing, like you're saying, discussing strategy and that type of stuff. And really, ultimately, we go on instructions. We can only advise. We can't force our clients to take a certain route. Obviously, we do have to work within the constraints of our regulatory rules. So there are certain things that we can't do. But if, you know, our advice to a client is we don't think you should issue proceedings, and they, you know, they want to go ahead and do it, then, you know, ultimately we go on instruction. But I think, you know, that is our role. It's to be that person in the middle, to kind of bring a bit of perspective to a situation, detail things like commercial realities of a situation. Often people get embroiled in a legal dispute without really necessarily understanding the steps involved or the costs involved, and that can often be one of the factors that leads people to think about, you know, most people, you know, they want to go to court, but when they realize how much it's going to cost, the time it's going to take, the resource, the energy, and everything, you know, you can sway somebody's decision a bit. So people management is definitely a huge part of our role.
I'm sure we'll come onto this later, but I'm picking up on lots of different key skills that you have to sort of use every day in this specific practice area. So I think that's just good for the audience to sort of be picking up on as well as we go through. Jamie, when it comes to litigation, you know, how do you come up with a litigation strategy, and what factors do you have to consider?
I suppose it follows very neatly on from what Preena's just said. The first litigation strategy is to listen, to understand what the client ultimately wants to achieve, because we will all have been there where that client expectation of what they want to achieve from the dispute is something that is certainly not something that the court can give. In which case, how are you going to navigate that? So I think the starting point for me is very much understanding overall what the client's objectives are and how realistic they are within the parameters, like Preena said, that we can go with. But also, you know, there are so many ways in which our kind of work moves in different ways, in such that often clients come with an objective, which, yes, you might not be able to get through court proceedings, but there is a route to get there, but it requires the other side to engage in that process. And it's trying to then look at the moves that could be made to kind of get to that. So that is ultimately a big one, client objective. Second one is client resource. Like Stephanie said, if you're dealing with a large corporate, it will be that maybe less concern about the financial ability, but maybe more the risk or the PR concerns in relation to that strategy. From an individual perspective, whether they can afford to run that case to trial, even if the objective is to not get there, you have to work on the basis, if you are embarking on that process, that is, you know, an option, and in which case, are they going to be able to see that through? What's the financial stability of the opponent? If you're seeking monetary reward, you know, are you throwing good money after bad? So there's yeah, I suppose client objectives, financing, time, I would say, is a huge one from a client perspective. And I think it's one that's probably the most overlooked by clients. I think lawyers are good at scaring clients about costs. Clients are good at shouting at us about what their objectives are. But what a lot of the people don't, I think, necessarily understand fully is the level of commitment that it requires from a client to embark on litigation. You know, for many, they will describe it as it's a full-time job. You know, how some of our individual clients manage to kind of do it as not their day job when it is our day job, and see things through to trial. It's, you know, it's a huge time investment. So how does that look for the client? Is that realistic? How's that going to work? So there's some of the kind of major considerations I suppose we look at, and then you look at the merits of the case. Like Stephanie said, you get into the document, you get a flavour for the case, you're looking at how does this look, how does it look against the objectives, and what's, you know, what can you do to get it to its end game, whatever that might look like in the right way. And you know, it's clients have different objectives. Like Preena said, you know, you might tell them it's the worst case in the world, and they still want to issue proceedings because they know that the second the other side receives the court papers, they're going to do a deal. Sometimes they do, sometimes they don't. Who knows? So you know, you're considering all these different factors, and you're considering them at every stage as well. So you're, like Stephanie said, the litigation strategy might change. It might turn out that yes, your client has forgotten to tell you about that telephone conversation or that meeting they had where they actually agreed something totally different to what they'd agreed earlier. You know, whatever it might be, things happen during the life of a case. So you then redirect, come up with a revised strategy, and you know, to try and get it to its end game.
Thank you very much. And Stephanie, you know, in terms of actually going to court, how often are you doing that, and how does that process work? And what's your role when you go to court?
So in terms of how often I'm in court, I mean, it really does differ year to year. I think Preena alluded to this at the outset. It's actually quite rare for cases to go all the way to full trial. The vast majority, well over 90%, settle before they get to the point of trial. So I have done 6 trials in the course of my career, which is probably quite a decent number based on those stats. But I am in court a lot more often than that, because you don't just go to court at the end of a matter for the trial. The court supervises the dispute in the course of its life. So you have case management conferences, you have hearings of interim applications and the like, which means that I'll be in court, you know, several times a year is probably the best way to put it. In terms of what my role looks like when I'm in court, so we have a split profession in the UK, as most, if not all, of those listening will know. So we have barristers and solicitors. And it is the barristers who we will instruct to do the advocacy in court. I will be there to take instructions from my client, and to liaise with the client about the proceedings, and also to give instructions to the barristers. I mean, it is generally the case that I will know the dispute much better than the barrister who is presenting it to court. I will have been living and breathing it for years, perhaps, in the run up to the court hearing. It is the barrister's job to absorb all of that as quickly as they can and present it, but they will rely heavily on me. You know, in the course of cross-examination of a witness, for example, something might crop up and they'll need to turn behind them and hear from me as to a relevant factual or legal point. You'll often see yellow post-it notes being passed back and forth between barristers and solicitors, which seems a very old-fashioned way of doing things in this day and age, but that is how we tend to communicate in the courtroom.
Great. I can see so many good questions coming in, so I'm going to take a moment and a second to throw some of those to you. But first, Preena, I always ask this question. I can always guess the answer, but would you summarize your work as sort of a very steady flow, or would you describe it as crazy peaks and troughs?
I think there are peaks and troughs in our work. Sometimes they can be crazy peaks and troughs. Sometimes it's a bit more manageable peaks and troughs. But and it's really driven by things like court deadlines, you know, the opening when courts are closed, because there are periods in the year when courts are closed. So summer, for example, there's a summer vacation period. Over winter, there's a winter vacation period. So that can be times when, you know, work is a little bit slower or things are a bit more manageable. But if you've got a big deadline, for example, you've got a disclosure deadline on something, you can be working really, really long hours to achieve your deadline. So and you know, disputes, we really are a distress purchase, and you know, people don't really want to be talking to a litigator, because if they are in a problem situation. So you know, people aren't in problems all the time. So there are periods of time when things are a bit quieter, either because, you know, you haven't got those there isn't lots of new work coming in, or you've got a bit more of a manageable diary in terms of your court deadlines and that type of stuff. So definitely peaks and troughs, but I think I would say that for other areas of law as well. I think it's very much peaks and troughs in this profession.
Yeah. And Jamie, is there such a thing as a typical day, or is every day very different?
Oh, that's a good one. I'm going to say every day is a little bit different. I think that's also changed post-COVID, and I guess the new way of working. We are hybrid. I'm probably in the office more than I am at home, in fairness. I'm probably 3 or 4 days a week in the office, on the whole. But again, it depends, like Preena said, I suppose, on what work you've got on at any given time. So in the run-up, we've had a lot of trials as a team over the last couple of years, and so in the run-up to those trials, it's all hands on deck. The team, you know, the resource that we put into those kind of cases increases. So those times are very busy. On other days, I generally find the days that I'm in the office, I do a lot more time on cross-office activities and cross-department activities. So we do quite a lot of support for corporate and our commercial team. Business development type stuff happens on the days I'm in the office a bit more. So those days probably have a little bit more of that type of stuff. My days at home are generally my days where I kind of like to just get my head into some of the documents on, do I call it my work, my kind of supervision, approving documents and all that type of stuff, just a bit more kind of quiet time. But I think that's partly reflected on the fact that when we were in the office 5 days a week, that wouldn't necessarily be kind of a bit more day specific, whereas I think it probably is, certainly for me now. So yeah, so no day is the same in the life of a litigator, I'd say.
That makes sense. Right, I've got some good questions here, so I was gonna ask them while we've still got a bit of time. So, question for Stephanie. Someone has asked, they said, I know Travers Smith is involved in many ESG disputes, so I was wondering if you could tell us about any experiences you've had with this type of dispute.
Yeah, absolutely. So ESG is, as everyone know, a hot topic at the moment. And it is absolutely a hot topic in the world of dispute resolution as well. And we are seeing in the market just more and more disputes come through under the ESG umbrella. That's a really broad label, to be clear, because you can have environmental disputes relating to, for example, oil spills in certain jurisdictions that fall under that label. Equally, you could have a form of sort of discrimination claim or a Me Too investigation falling under the S, and a whole host of other things in between. So it does cover quite a lot, and as is often the case with these sorts of trends, people like to label things as much as possible, and so you will hear people talk about ESG disputes quite a lot, and they might not actually be all that different to what we've seen in the past, but they've just been packaged up and labeled in a particular way. The claims that we are seeing quite a lot at Travers Smith under the ESG umbrella are parent company liability claims, which is an expanding area of the law, where a claimant group seeks to hold a UK entity responsible before the UK courts for actions taken by perhaps its subsidiary in a different jurisdiction, or even by an entity within its supply chain in a different jurisdiction. It's sort of stretching the boundaries of tort law to hold the parent company in the UK liable for things that have happened elsewhere. And I was involved in a series of cases relating to really horrible allegations of human rights abuses in Kenya and Malawi. And my company was a UK PLC, and the allegation was that UK PLC, for the human rights abuses in Kenya and Malawi, notwithstanding the fact that the subsidiaries and the employer of the relevant employees who have been subjected to these alleged abuses were in different jurisdictions. That's a really interesting expanding area of the law. That's probably the closest ESG nexus that I have seen in my own litigation work.
Great, thank you very much. Preena, I think you actually sort of answered this earlier, but someone asked sort of quite early on, how do you manage a situation where a party is unwilling to engage in mediation or arbitration and insists on litigation? And I think you said you just have to do what the client wants, but is there a particular way to handle that?
Yeah, absolutely. I think, often our instructions, people who are instructing us don't necessarily have experience of litigation, arbitration, or mediation. So sometimes those views can come from a lack of understanding of a process. So explaining a process and the benefits of a process can help. Also, that there really used to be this perception that if you engage in any type of mediation where you may want to resolve a dispute or you're making an offer to settle, it's showing weakness on your part, and that was really, that there used to be that perception, but we're moving away from that now. And I think really it's about explaining the risks of taking an approach, and we'll come on to this later in terms of kind of changes, but actually that there has been changes in terms of the rules on mediation, because actually the courts now do have the right to order parties to mediate. So often it's not really an option that your client it's not really a negotiable point, really, because you can be penalised by the court for not doing it. So that's kind of enshrined in the rules that govern the way we conduct litigation in England and Wales. But with mediation, even before that was in place, it's very much something that the court expects parties to do. And if you don't, you need to have a good reason for it, and you can be penalised for not doing it. So often, just in those situations, it's just explaining the process, the benefits of it, the risks. And when you kind of lay everything out for your client like that, you find that you can kind of bring people around. But if your instructions very much are, I don't care what you're saying, I still don't want to mediate, you just make sure you've given the health warnings and you go on instruction, because like I said, you can't force somebody to participate in something they don't want to.
That's good insight. Thank you very much. And just before we move on to that hot topics and future trends section, Jamie, just one question for you, which is actually one of the questions I skipped over earlier, which is talking about working internationally. So someone said that Trowers obviously works across several jurisdictions. So have you ever been instructed on cases with sort of international remit or in international offices?
Yes, in short. So as a firm, we have 4 offices in the UK. We have offices in the Middle East and parts of Asia. So we have quite a lot of breadth, I suppose, in particularly in those markets. Have I personally? Yes, we've done some work with some of our Middle East offices on a variety of different things, including fraud investigations, including large commercial contracts that are subject to UK law, but relating to parties based in the Middle East. We have we see obviously international arbitration work, less so in our team in Birmingham, but as a wider practice. So yeah, a lot of our work has an international dimension. Primarily, I suppose, at the moment from the Middle East kind of region, but it can be all sorts. You know, we're looking at we had a trial early this year where one of our clients was based in Jordan, and we used one of our Middle East offices to assist with dealing with witness statements and the like. So it's quite a nice seamless process, I guess, because it's internal, but it's it's dealing with some of the barriers that you might otherwise kind of face. So yeah, definitely large aspects of international work on litigation and kind of probably across the wider piece as well.
You. Okay, moving on to talking about what everyone is talking about in your practice area. So Preena, you hinted at this. I feel like I might come back to you first. What's happening? What's changing? What should people know about in dispute resolution at the moment?
Yeah, so one of the main things is kind of this move towards mandatory mediation. So there was previously case law that said that the courts couldn't force people to engage in mediation. And there was a Court of Appeal case last year that said that the courts did have the right to order parties to engage in mediation. I think there's been another case since then, and there's been some changes to the civil procedure rules, which are the rules that govern the conduct of litigation in England and Wales. And those rules now enshrine the fact that the courts can order a party to mediate. Now, from personal experience, even before those rule changes came in, commercial cases that I've been involved in, judges have actually put in orders. So Stephanie mentioned about the courts kind of managing a case throughout the life of it. You'll have things called case management conferences where the court sets out what are called directions, i.e. the steps that the parties need to take a case to trial, which that there are a number of them. And in cases that I've been involved in, the court has actually, previous to these rule changes, that actually ordered that, look, I'm dealing with two commercial parties here. I'm expecting you guys to engage in mediation. And if you don't do that, you're really going to have to explain to me why. So that is one of the big changes in the area, which is, and actually it's probably a change that's reflective of how most litigation is conducted. I think Jamie touched upon it, that litigation is not mutually exclusive to mediation. So when you're in a process, you might be in the process, or you might be at the beginning of a dispute, the end of a dispute, but they kind of go hand in hand. So I think it's very much a welcome move in terms of making that in the rules, but I also think it's reflective of what's going on in practice anyway.
You anything to add, Stephanie or Jamie? Things coming in, things changing.
You want to go, Stephanie, first?
Yeah, I'll go first. Things changing. I mean, things. The funny thing about our world is that things change all the time and quite quickly, because all it takes is one decision, to point people in a particular direction. In terms of things that I am seeing and change in my world, I am seeing an increasing number of group actions brought by claimant law firms who act exclusively on the claimant side, in conjunction with litigation funders who pay their fees, and enable the relevant individuals who form the group of claimants to pursue the claim. And that could be a claim of the nature that I outlined a short while ago, the human rights abuses ESG claim, or it could be something else entirely. I do quite a lot of so-called securities litigation, so shareholder litigation arising out of corporate IPOs and the like. And I think because these claimant law firms and litigation funders are viewing litigation as a business, effectively. I mean, it is a means by which they can make a lot of money by generating claims. We are just seeing more and more come through in that sphere. and more and more creative claims come through. They will look for a way to navigate through the law to be able to mount a claim and frankly put pressure on the defendant or defendants to settle. So that is a definite theme in terms of what I'm saying. It's not so much a change, but it's very different to what it looked like, say, 10 years ago. And those sorts of claims and strategies are just increasing.
Do you want me to step in now, Bethany? So, funnily enough, I was going to say both. I was going to separate them out actually, but I was going to say both of those. One is group actions. We've just actually had a big reported decision in the last few weeks on a group action for 430 odd claimants in relation to investments into student and holiday accommodation. So that was a big 10-week trial earlier this year that our team worked on. So having just seen that within the team, it wasn't one that I was specifically worked on. But yeah, I definitely see that as a kind of growing area, as well as I suppose the kind of very much more claimant type. I wouldn't put us in that bracket, but there are a lot of firms out there now simply doing group actions, running them at quite low cost, and looking for the highest numbers for all sorts of things, whether it be data breach, whether it be all the things Stephanie said. So that is definitely I think a growing trend. I also think litigation funding generally, I think the market is expanding. I think it is picking up more and more cases. So again, just going back to basics on this, litigation funding is where a third party steps in to pay the legal fees and fund the litigation through to trial, or however far it needs to get. And the premise of that is, like Stephanie said, these are businesses that want a return on their money. So if, say, they lend £1 million for a piece of work, they'll want everyone to have probably an element of risk, i.e. lawyers not being paid in full, counsel not being paid in full. And they will then want that money back, and they'll then want a big return on their money. So if they succeed at trial, they get the first whatever X million of money that comes out at the end. There has been some decisions around kind of how those litigation funding agreements are structured and stuff, but I won't get into that. But I think that's going to be a growing market, and the potential regulation around that, or how what the parameters of litigation funding are moving forwards. But essentially, the benefit of it, I guess, is the fact that it allows claims to be brought that might otherwise not be brought, that clients and particularly individuals might have very good cases that they deservedly should bring through the courts or through whatever process to get to the end game, but they just, going back to what I said at the outset in terms of what their financial resources are, they just can't afford to. And sometimes you do get the David and Goliath situation where the large corporates or the rich group or whatever they might be take the view of, well, I'm not going to engage because I know he hasn't got the money or she hasn't got the money to bring a claim, so what's the worst they can do? So it is an opportunity, it is an avenue for clients to bring claims that they might otherwise struggle to do. So it gives access to justice to a number, but I think there'll be more and more on that, and more nuances and ways in which they can work. And I think it would be remiss if we didn't say the words AI, but I'm going to kind of go AI in the same way that Stephanie said ESG. It is a thing. It is a label, and realistically, how it will change our lives, I'm sure if you hear some things, anyone looking at a profession in law may as well not, because computers are going to do it all for us in years to come. I think there are absolute improvements that can come along with better use and more use of AI. I think there's already a lot of things in place. The likes of LexisNexis have their own kind of AI tools and all that kind of stuff. So there's loads of different things already out there, but I think there will be things that refine. I think I was at a round table not long ago with one of the big accountancy practices talking about the impact that AI might have on expert evidence in court proceedings, and how it might be used, how it might be a challenge both in terms of investigations, but also then how it might be used to present in court. So I think there are lots of things to come on that front as well. That's without touching on the AI litigation, but just to think AI in terms of its use and support in litigation. So probably that's probably it for me.
Thank you. I was going to say, I think what struck me listening to your speak today is sort of the importance of those human skills in what you do, and when you're speaking to clients, and it's like, a robot is not going to be able to replicate that, which is definitely a good thing. I'm aware we only have 5 minutes left, which is crazy because this has absolutely flown by. What I want to do is end right at the end with some advice from you all on sort of getting into this area and those skills. But Jamie, I know that you've prepared a short case study just to sort of talk through an example of a case that you've worked on. So I'm going to hand over to you for a couple of minutes, if that's okay.
That's absolutely fine. So when I started preparing this, I was going to, and I'm still torn as to which way to go. I was going to go down quite a traditional kind of piece of litigation, route, a commercial contract claim. So I'll touch on that first, but then I might just kind of flip it and do a very quick summary on something that's very different, which shows the breadth of what we do as litigators. So we've recently advised and taken a matter to trial in relation to a case to do with face masks. It was a commercial contract type dispute, acting for a manufacturer of face masks and another individual involved in the kind of deal making and commission based process. This is all to do with COVID, so very, very interesting point in time. The defendant party was a big logistics company, and they subsequently it ended up going through to court proceedings. So it started off in pre-action correspondence. It got into proceedings being issued. The defendant then brought a third party claim against an agent in effect, and subsequently obtained a freezing order, worldwide freezing order against that individual. It went through very much the traditional process that you probably all see and learn about, i.e. it went through the stages of disclosure. There was a summary judgment application. That was an application to try and kind of kill the claimant at a very early stage. It then went through to witness statements. There was the most interesting expert evidence of a very nuanced area of face masks during COVID. So you can imagine there were very few people in the arena to speak about that. And we ended up in a 2-week trial. So that was one that, I say, unfortunately, the circumstances dictated or, resulted in that matter going through to trial. Please say we succeeded in a large part of that claim. But that's not necessarily the end of the matter, because the way that the court system works, there's then the opportunity to seek permission to appeal, and things can move forward. So that is, I suppose, the traditional one. I was going to speak a bit more on that, but I thought what I would do in light of some of the kind of wider questions I think we've had in understanding, what litigation really looks like is, some risk advisory side. So I've recently been advising some shareholders. I've been advising some directors of a company in relation to shareholder and director matters, where effectively the crux of the matter is trying to navigate and avoid a dispute from arising as a result of circumstances that have arisen in relation to one of the shareholders, who also happens to be a director but not active director, effectively not signing off documents, not doing things that he needs to do to help the company progress, and that there are all sorts of risks to the company as a result of certain inactivity. So our role then was very much kind of looking at, right, well, what is the position? What aspects of these are corporate director related matters and what aspects are shareholder related matters, and dividing them up and making sure that we are only dealing with those that we can do on behalf of the company. And essentially that has very much been a close strategy, working with the corporate team in terms of looking at what could be done under the articles, what rights the directors had got, and also looking at putting mechanisms in that everyone could fundamentally agree to, that ultimately gave the if we call it the problematic shareholder comfort in terms of what he wanted to see in terms of what the company was doing, and keep their feet in, because fundamentally this was a matter where someone wanted to have control but didn't really want to be involved, but then didn't really want other people to be involved either. It's a common dynamic in owner-managed businesses. And it was to kind of structure things in a way that gave everyone sufficient comfort that the company could properly run in the way that the company and those involved day to day with the company needed to operate, but equally gave sufficient comfort for the shareholder to know that they'd got the rights to kind of look at stepping in, they'd got the rights to kind of see what was going on. So it gave transparency and comfort to everyone. So it was trying to navigate to that position, if you like. So appreciate that was quite short and sweet, but I think it touched on some of the stuff that Stephanie mentioned in terms of these kind of nuanced shareholder kind of bits, but it's a big part of litigation is not simply court proceedings and that route, but very much kind of trying to navigate and circumvent problems from becoming bigger problems.
Great, yeah, thank you. Two very different examples there, which I think was really helpful for the audience. Okay, we are out of time, but I'd like to finish if each of our panelists, while I just prepare the last poll, could go around and just maybe share one piece of advice they have for someone looking to get into this area. We've got lots of undergraduates watching today, and lots of people going, what can I do to get in, or how do I find out about this? What should I know? So Preena, I'm going to go to you first. Any advice for our aspiring dispute resolution solicitors today?
Yeah, absolutely. I think it's just in terms of for the career as a whole, perseverance, because I think the route to training, it's very competitive. It was hard when I was getting into it. I feel like it's hard. It's even harder now in terms of training contracts and that type of stuff. So it's just perseverance. And in terms of dispute resolution and getting into that, me personally, I was a paralegal before I actually qualified as a solicitor, and I was in the commercial dispute resolution arena in my paralegal work, so that really helped me. So I think if someone has an interest in this area, definitely trying to get some work experience in it is really helpful, and getting some of those practical skills. And then the basics of just kind of keeping up to date with legal developments and reading up on case law and that type of stuff. But it's also an area that's often on offer during training contracts as well. So hopefully when you do get to that position, it's something that you can express an interest in and have an opportunity to see what it's all about.
Great, thank you, Stephanie.
I think that the beauty of disputes work or dispute resolution is that it is perhaps a little bit more accessible than certain other practice areas might be before you actually enter the profession or start to undertake the work at a firm. It's very difficult to really get to grips with what a tax lawyer does or a pensions lawyer, and before you're in the firm and doing it yourself. But with disputes, there are quite a few ways in which you can get greater insights. That might be going along to court. Courts are public places. You can go and watch in the viewing gallery and get a bit of experience in that way. There are lots of opportunities to volunteer at legal advice centres and citizen advice bureau sessions and the like. I mean, I do a lot of that work myself pro bono still in this role. I think it's a really, really good way to just cut your teeth as a litigator and start to understand how disputes matters work. And then more broadly, there's a lot out there in the legal press, but also the mainstream press about cases of interest. I did a very, very large fraud case a few years ago, and it's ongoing now, but we were in court a couple of years ago. It was the HP autonomy fraud trial. It was a 10-month trial. It was all over the papers. It still is. There's lots to read about it. So you can take an interest in that way. And because of the breadth of the practice area, you can really delve down into what it is about it that particularly interests you. That might be fraud cases, that might be shareholder disputes, that might be ESG disputes, could be anything.
Great, thank you. And Jamie, I'm going to ask you, but I'm also going to launch this poll so we can get people answering their key takeaway while you give your advice, please.
No, that's fine. So I think I would keep I would say look at all the available information you can. Like LinkedIn is often a good thing because litigators don't necessarily get to say a lot about what we do unless we can say about what we've done. So, looking at what, litigators, litigation lawyers have posted on LinkedIn, cases they've been involved in, barristers' chambers, exactly the same, forensic accountants, and some of those third parties that are often involved in, in our disputes, they do a lot of articles on big piece of work that they've been involved in from their role as an expert. So again, you get to see it from another dimension. I think when you get into training contracts or apprenticeships or anything such like, maximize the opportunities in every different department, because going back to the point we said about the breadth of litigation, if we've got a restrictive covenant related dispute, we're working really closely with our employment team. If it's a commercial contract dispute or a corporate dispute, we'll be working with our corporate and commercial teams. Private wealth disputes with the private wealth team. So depending on whatever kind of part of the litigation practice area you're involved in, having the strongest strong relationships and understanding of the underlying practice area is really, really vital. So, even if you want to be a litigator and you get given a corporate seat, don't go, oh, I've got no interest in corporate, because actually you're going to learn loads of really useful stuff that you will then be able to translate into your role as a litigator.
Great, thank you so much. I was going to share these results, which looks great because that was kind of the aim, was to people to know what the work of a solicitor in this area involves. And I have absolutely thoroughly enjoyed hosting this panel. You've almost made me want to become a dispute resolution lawyer. So thank you very much for your time today, and thank you, thank you again to our panelists for being so honest and sharing their insights and experience and advice. Thank you to everyone who has joined us today. We hope that you've taken away your key takeaway, can go on to sort of research this practice area more, and maybe even use what you've learned today in your applications to firms. There'll be information about the firms here today in that follow-up email, as well as links to our upcoming events as well. And there will also be a short feedback survey popping up once we close this masterclass. If you could take that and let us know how you enjoyed today, what other topics you want to see us cover. But I think that's it. We are definitely overrun. So thanks once again to our panelists, and we hope to see you at our next Law Careers Net Masterclass. So thank you very much.